In the last lecture, I had discussed about the importance of commercial disputes getting adjudicated through new statutes. For example, the IBC, the Insolvency and Bankruptcy Code. See, in case of resolution of insolvency or corporate insolvency resolution earlier, it was through the DRT, it was through the Securitization Act, and it was also through the company courts in case of incorporated companies under the High Court jurisdiction under 433 winding up oppression and mismanagement. So High Court was equipped. But subsequently, there has been the development of NCLTs, National Company Law Tribunals, with technical as well as judicial members to effectively and unilaterally and efficiently dispose of commercial disputes of corporates. Corporate insolvency resolution process after the IBC has been through the methods and manner known to the Insolvency and Bankruptcy Code 2016. And you see, in the Insolvency and Bankruptcy Code and the manner in which the operational creditors and the secured creditors were dealt with and their rights adjudicated, and how the resolution applicants would come and apply for a particular company's debts resolution by way of a calculation they will be making to the committee of creditors, and how that will be approved, and what are the after effects, the 1 year holiday from prosecution for the resolution applicant, and the reasons and the justifications for it, and why the courts, the Supreme Court, the NCLT, and courts across India would be supporting the IBC and the scheme of the IBC. This has been very elaborately dealt with by Honorable R.F. Nariman sir in the Committee of Creditors of SR Steel matter. That is, in the IBC, there is the corporate insolvency resolution process, and there is a corporate debtor, and in case of his inability to pay the admitted liabilities, then he shall go to the NCLT. Either the borrower himself shall go, or the secured creditor or the operational creditor shall go. And once the liabilities are proved as per the IBC, then what happens is the resolution process will start. The first thing will be whether the corporate insolvency resolution process can be solved by keeping the company as a going concern, and whether the company itself can give a resolution plan. On the failure of the company to give a resolution plan, then the secured creditors and the committee of creditors, who are one and the same, the committee of creditors are nothing but the secured creditors, and to some extent as per the extent of debts admitted by the NCLT, the operational creditors, they will form a committee of creditors, and they will entertain bids from different people to keep the company running, to settle the debts, and whether there is a justiciability to the amount at which the debts are considered settled by the COC. That was the point, important point, the commercial wisdom of the committee of creditors, whether that is a subject matter of any judicial scrutiny, or it is impervious to judicial scrutiny. That was what was the main point in the committee of creditors of SR Steel matter. And it was held by the Supreme Court that the commercial wisdom of the committee of creditors, consisting of the secured creditors and their powers to accept a particular plan submitted by the resolution applicant, need not be a subject matter of judicial scrutiny unless it does not provide for the implementation of the plan, or it is contravening to any major laws that are prevailing at the time of the approval of the resolution plan by the NCLT. So this was the law that was settled by the Honorable Supreme Court with respect to the commercial wisdom that need not be disturbed by courts, and commercial wisdom unless it is extremely capricious or against public policy, will not be disturbed. And the resolution applicant, once he gets the plan approved with the committee of creditors and by the NCLT, will enjoy a period of 1 year against all judicial scrutiny and against all claims. And all claims forthwith after the particular initiation of the corporate insolvency resolution process and the adjudication of claims and the acceptance of the plan submitted by the resolution applicant, that is a person who is trying to buy out the physical and intangible assets of a particular corporate debtor, because those assets are in control of the secured creditor. He will come and pay a particular amount of money, and it is up to these scheduled creditors to accept it or not. That is a commercial wisdom. So they will make a committee of creditors by way of a voting mechanism on the basis of the exposure of the total debts that are serviced by them with respect to the corporate debtor. They will make a calculation and they will form a committee of creditors and they will decide things by voting. And this commercial wisdom is not subject to judicial scrutiny, because it is for a particular creditor to decide how much debt is okay for me, what is a bad debt and what is a good recovery. So this will not be interfered with the courts, and this cannot be, this is not any matter of public interest or matter of public funds, even though it is a public fund, because these are public sector unit banks, most of them, but still their commercial wisdom to accept a particular amount of sum that is given as a total settlement for the recovery of the particular corporate debtor by a new resolution applicant who seeks to buy it out. This is non-justiciable for most parts, and it will not be interfered. This principle was settled, and this is because, you see, this is a new resolution mechanism that has come into this country, and this requires all subsequent judgments of Lordship Nariman would show that this kind of new debt resolution mechanism requires all the support of the judiciary, because legislative intent, which is in goodwill and for proper resolution of corporate debt, has to be supported by the courts. And across the board, NCLT and Supreme Court and other courts are supporting this IBC, and also the manner in which a particular debt is treated as serviced, a particular debt is treated as closed, and a particular corporate insolvency resolution process is treated as solved by a particular resolution applicant. These are commercial wisdom, and nobody other than the concerned scheduled banks with the secured creditor, they only have the right to decide and take a call on it. So this was the commercial wisdom as explained by the SR Steel judgment, wherein the commercial wisdom of the scheduled creditors is accepted unless contravening, as I already told. One is the provisions of law that are already in force in time being, and other is it does not give a provision for implementation of the plan. So these are, unless there is a major contravention, by and large the commercial wisdom that went into acceptance of a particular resolution plan will be accepted. And you see matters of haircut. So in this case, if there is we see that around 15-20%, maximum 25-30%, only that much amount is being paid back to the commercial banks, secured creditors, and the remaining money, public money, is treated as bad debt, and that 30% flowing back of public money through the resolution applicant into the coffers of the secured creditor is treated as a decision that the secured banks, secured creditors have taken, and the courts will abide, and the courts will not upset the apple cart. This is the main aspect of this judgment, the commercial wisdom of committee of creditors, in this case SR Steel. So it is upheld by the court, unless, as I already told, it is in variance with the IBC settled provisions or any law at the time being in force, or if it does not provide for the implementation of the plan. For example, if the approval of the a particular resolution plan does not provide for the implementation of the plan, then it is a subject matter of judicial interference that is within the IBC, not through a writ court or something. It is within the IBC. There are provisions to the appeal to the NCLAT and later to the Supreme Court. So IBC is a complete code. It is dealing effectively with the corporate insolvency resolution process and how the public debt of scheduled banks are serviced by the resolution applicants, and this has come to force and is in vogue. That is what the judgments in SR Steel means. The next one is the Internet Mobile Association versus RBI. In this matter, the Supreme Court dealt with a very interesting aspect of cryptocurrencies. Cryptocurrencies like Bitcoin or several cryptocurrencies, there are thousands or hundreds of cryptocurrencies across the world that are being traded by online platforms. So RBI gave a circular that you see the regulated entities of RBI should not promote or deal with such online platforms which are dealing with cryptocurrencies. Now, the Internet Mobile Association, which is a group of online cryptocurrency trading platforms, they approached the RBI, approached the Supreme Court against the RBI circular. And in this case, it was held that RBI circular for regulated entities that are regulated by the RBI, which means banks or regulated entity as per the RBI Act, any financial service provider that is monitored by the RBI, cannot deal or permit to be dealt with online platforms, internet platforms that trade or deal with cryptocurrencies. So this kind of regulation without any corresponding damage was held to be bad. The court asked the RBI, okay, you are telling this cryptocurrency is dangerous, there might be terrorist involvement, we do not know whose funds these funds are, whether they are laundered, whether they are parts of criminal proceeds, and whether any tax evasion has happened. All these things are debatable issues, and we do not want to deal with such risks, financial risks. And if the RBI circular states so and wants to control its regulated entities in so far as they are concerned with the trading of cryptocurrencies, the Supreme Court asked, what is the damage? What is the damage? The doctrine of proportionality was argued by the Council for the Internet Mobile Association, and the Supreme Court asked, what is the proportionality theory? What is the proportionality test that can be held for you? You see, you are telling there is damage, but where is the damage? Can you show the damage, actual physical damage to regulated entities that have earlier traded with such cryptocurrencies? And in the failure of the RBI to show that the regulated entities that had dealt with cryptocurrencies on online platforms have suffered any damage, the RBI circular was struck down. So this is one judgment where online trading, online platforms, they got some genuineness, some stamp of approval from this court. In so far as unless there is real damage on mere perception of threats, there can be no regulation. That was the principle. So there is in new online platforms, in new commercial areas of development in currencies, Supreme Court has held that regulation is possible, regulation is accepted, provided there is accompanying damages physically or financially to such regulated entities as monitored by the RBI. So that was another important leading judgment of the Supreme Court. And the other one was the Municipal Corporation versus Municipal Ujjain Corporation of Ujjain judgment. See, this is a case where the interpretation versus PVG India, Lordship, Municipal Corporation Ujjain and another versus PVG India Limited. In this matter, Lordship Gowda, Gopal Gowda had made this judgment. And in this matter, if you had seen, the question was judicial review of administrative or arbitrative disputes. Whether how much is the extent of judicial review into commercial contracts, how it can be done. Whether technical disputes can be interfered with by the Supreme Court at the inception stage itself, and if so, under what grounds. The Supreme Court clearly held that it is averse to interfering with disputes that involve commercial and technical know-how unless it is perversely bad, perverse and against public policy, or strikes the conscience of the judiciary. Unless it is very arbitrary, the judicial review of administrative adjudication is to be detested, and just because someone rushes to the court and asks for resolution of a particular auction process or fraud is being alleged, just because somebody is alleging, it cannot be adjudicated, because these are normally done by qualified technical people. So these technical decisions made by qualified technical people cannot be supplanted by the Supreme Court in its judicial review powers, mainly because the basic constitutional principles of that strike against arbitrariness, that strike against free competition, only if these are affected, Supreme Court will interfere. Otherwise, normally the processes that are agreed upon and are normally available in a particular business environment should be respected. This is the judgment of the Supreme Court with respect to the Municipal Corporation Ujjain versus BVG India Limited. So this is also a major judgment. The another judgment is SL Crop Care Limited versus Competition Commission of India. So this is a case where for a group of companies, 3 or 4 companies, had prevented bidding by forming a cartel, by not permitting an auction to go, because they were the main business stakeholders, and no stakeholder other than them would come and make a bid, or bidding was rigged fully. So by this kind of constant rigging and cartelization, that prevented open competition, and the Competition Commission of India had imposed a penalty on these cartels by identifying them and giving them opportunity, and finally it was adjudicated that they were liable to pay a penalty of 10% of the turnover for a particular period of time, and it was in principle that penalty is correct. However, it could relate to only the product in which the particular cartelization and bidding happened, not in the entire turnover. You see, for example, there might be 5 products the company might be making, and in that the product in which the cartelization happened would be only one product, and there are 4 other products, and in those there was no cartelization. It was not connected to the matter in question. So if that only constitutes 20 rupees out of 100 rupees, how can you get the calculate the turnover? So it was held that only that product where the cartelization happened, only that revenue could be taken as a subject matter of penalty and the calculation of the turnover. So this was one judgment of the Supreme Court. These were the main commercial litigation and commercial disputes resolution that the Supreme Court did in the last few years, last 5 years. And IBC is very important. IBC and cryptocurrency, these are all forward looking, these are the future, you see. IBC is shouted as the next great thing that happened to commercial dispute resolution, and cryptocurrencies are the future of the next few decades. Therefore, Supreme Court has been progressive and has been exploring such disputes, commercial disputes, and new concepts of litigation in commercial areas.